Woo! Hey, folks. That's Colin.
No, it's not. Howdy, folks. Colin and Shreya Lay here of LayRoots, an asset protection and estate planning law firm.
In Seattle, Washington.
Today, we want to add to the list of things we've talked about an interesting asset protection strategy. It's where you dig a hole in your backyard. Pirate plan?
Wasn't that kind of the premise of that one podcast, S-Town, that we listened to, where people were digging around in that guy's backyard?
Because he was unbanked.
Yeah.
I guess we want to talk about bad asset protection strategies.
Yeah, that we hear often.
Bad moves. And yeah, I think recently, in the past couple of weeks, had a couple of folks who were panicked about a pending lawsuit or something coming up. And basically what they did was they just started giving their assets away.
Yes.
Just started giving them to family members, like, here you go, take my house. Here you go, take my LLC.
Yeah, take my LLC, take my house, take the car. Anything that they felt had a larger perceived value, they're like giving it away.
Yeah. And it maybe makes some sense on the surface. It seems like if it's not mine, you can't take it. But this goes back to the point we often talk about, that asset protection planning has to be done early. It has to be done when the skies are clear, the waters are calm.
The birds are chirping.
Because otherwise, people are looking at, there's things called voidable transactions. So essentially,
some people call them fraudulent transfers.
That fraudulent transfers is the old school term for it.
Yeah.
I think people are a little more sensitive these days.
Right.
That sounded really harsh with the word fraud in it.
I know.
So it's actually a better description of it is voidable transfer. Essentially, that's because the transfer you made could be voided. So say you give away your home to your cousin for a while, and you're like, I can't take any of my stuff because somebody else owns it.
Right. And the judge may look at you and look at that fact pattern and say,
Right. And they just undo that transaction. The home gets placed back in your name, and then the creditor can take that home from you, or whatever asset it was that you tried to give away. So it's not good. It definitely doesn't look good in a courtroom, and it's not a very effective strategy, especially if you just gave it away and there was no exchange of value. I mean, even if there was an exchange of value, that's something that could be undone. There's basically a window of time after you transfer an asset to which a judge could, or a court could, undo or void that transfer. Depends on the asset, depends on where you are.
Especially if they feel like it looks suspicious or was done under suspicious circumstances.
Bad optics.
Yes.
The other reason this is a really bad idea is that maybe they won't give it back to you.
Right.
I mean, if your idea is that you give it away and then your threat from a creditor goes away, then the person will give you their home back, but maybe they won't.
Yeah, maybe they decide that they like having it.
So that's, the obvious downfall is you give something away with the expectation that somebody gives it back, but they don't end up giving it back. And
yeah, that would suck.
You'd be pretty sad. Then you'd end up losing the asset anyway.
Right.
All right. So, folks, if you're thinking of just giving your stuff away willy-nilly as an asset protection strategy, just don't do it.
Maybe talk to an attorney first.
Call
a professional. That's a big move. It's a big move. Maybe think about it a little more and get some professional guidance.
Take care, folks. Put those shovels away.
Talk to you later.